All rise.
Good morning, Your Honor.
Good morning, Your Honor.
Missing one juror? Two jurors. All right, well, we need to have a discussion about this evidence rule, so as soon as the defendant comes up, we can do that. We heard from the marshal? Morning, Judge.
Good morning, Judge.
Well, look, if any of you have your computers with you, I have a case for you, 556 F3rd 151.
Ooh, one more time?
556 F3rd 151. Here, you can all read it on my iPad if you want to write it.
Okay.
It's a recent Third Circuit case on present sense impression.
Your Honor, just a question. Wanted to make sure you got my letter on Friday.
Yes, I did.
Okay,
I have it
thank
right
you.
here, thank you. With the other additional cases. We'll discuss that as soon as the defendant comes. Okay, thank you. Well, this will take 5 or 10 minutes to have this discussion. Okay, thanks. Were you looking for me at anything else, or what? Do you want to go do it right now? I'll go in with you. All right. Okay. They're on my table, I presume? Yes. What? Oh. Great.
Okay. Do you want to go see him?
I'm sorry, what did you want?
I don't know. I just have to go.
so that's,
But I can go back.
No, I don't think so.
Thank goodness for easy questions.
Yeah, that's what I thought.
All right, we're down to one juror missing.
Okay.
This is where the serial number should have been.
yes. This number on here. See if I can know.
All of the jurors are here, so now all we need is a defendant. All right, well, look, let's have this discussion, and we'll rule on it until Mr. Seals comes in here. But I want to repeat what I mentioned last week, is that, in my view, the present sense impression under Rule 803-1 fits this better than the government's argument that it should be admitted not for the truth of the matter asserted, but to show the effect on the defendant. And so I found this case, United States versus get the right case. Green, 556 F. 3rd 151. Now, in that case, Judge Sleet in Delaware had admitted the statement as a present sense impression. He was reversed on that because the statement was made 15 minutes after the event in place and after some questioning. But in this case, the statement is being made simultaneously with the police coming into visual conduct with Brian Seals, the brother of the defendant. So I didn't ask Ms. Maggid or Mr. Zork what your reason is for disputing, or you don't dispute it, or you think your argument is a better one.
Certainly, Your Honor. We are confident enough that we are correct in arguing that it comes in as not hearsay, that I'll actually argue against our original position regarding present sense impression, because we do feel that it would not be reversible error and it is the proper course to admit it as non-hearsay. And to admit it as non-hearsay because of its relevance. It comes in as non-hearsay because it is relevant to the state of mind of the defendant. And that's what's at question here. The defendant's state of mind, his consciousness of guilt, that is relevant evidence. If it comes in as a present sense impression, I believe that the relevance is a little bit less clear because it's the present sense impression of his brother Brian Seals, but Brian's not on trial here. It's Ryan who is on trial, and Ryan Seals' state of mind, his consciousness of guilt as he looks at the approaching officers and throws the gun, that's what's relevant. And the fact that he heard a warning and had that reaction, that's what's relevant. It absolutely doesn't matter whether it was true or not. The truth of the matter does not matter. Some of the cases I cited to you included ones where someone heard something that turned out to be factually incorrect,
right,
but they had a certain reaction to it, and that reaction was relevant to the case.
Well, I understand the difference between admitting something for the truth of the matter and admitting something just to show that it was said or for the effect on another person. But then you have to give the jury the instruction that it's not being admitted for the truth of the matter asserted, which in this context I think is hard to understand. And also, there's no Third Circuit case
approving this argument. The cases that you've cited are all from other circuits. There's no precedential Third Circuit case that anybody cited here. Now, the clearest example of a present sense impression doesn't often arise in a criminal case, but rather in a civil case, such as in an automobile accident. You have a crash, and one of the bystanders, a third party, says, "Oh my God, the Buick went through a red light," and that's generally admissible as a present sense impression. Now here, Brian Seals is a third party. He's not a defendant in this case. So it would seem to me that what he said is admissible, but that doesn't necessarily, then you still have to show that Ryan Seals, the defendant, heard that, or allow the jury to infer that Ryan Seals may have heard that. But you have to make that argument under your theory as well. So it is possible that I could admit it under both theories, but then the issue is what explanation I give the jury. All right, Mr. Adamo, what's your argument?
Well, Your Honor, I briefed the point. I think the key issue.
Wait, did you send me a brief? I didn't get it.
No, sir. No, I previously briefed this issue with present sense, and my argument really hasn't changed. There's no knowledge. You have Brian Seals making a statement, assuming the court admits that. All right. Then there's a 403 issue.
Well, wait a minute. There's no legal theory on which I can preclude the police from testifying that they saw Brian Seals and they heard him say something. The question is the content of his speech admissible? All right. I know he denies even being there.
Well, then the issue becomes, all right, whether or not, like I said in my brief, whether or not my client understood it, whether he heard it. All right, because
that's a fact issue.
But they're using this, they're making an inference, and it's a 403 issue, Your Honor. The prejudice here is that they're working in cahoots with one another. It's a reasonable inference that they're going to try to drive through, and there's no evidence that my client heard it. You're talking about a yell way up the block, something that happened spontaneously.
Well, that's up to the jury to prove. In my view, that's not a question under the rules of evidence. That's a question of proof, whether whatever Brian Seals, well, first of all, I don't know if Brian Seals is going to testify or not. It's not about, and I'm not asking you whether he is or not. Okay, but the police are going to testify that, and the fact that he's the defendant's brother is relevant up to a certain point, but it's not relevant as to whether the defendant heard what he had to say. So that's a question of fact, of proof for the Commonwealth. They've got to prove that the defendant was in possession of this gun. All right, and as we know, they didn't find the gun on the body of the defendant. The testimony is that to allow the jury to infer that the defendant had it and that he threw it into the bushes. Is that right, Ms. Maggott?
Yes, Your Honor.
All right. So this is a case of constructive possession, all right, and they're going to depend on circumstantial evidence. Now, one of the circumstances is that Brian Seals said something, all right, and I don't know why I can't admit this under both theories. That I think I can find that it's admissible as a present sense impression, and I think I could also find that it's admissible for possibly having an effect on the jury, having an effect on the defendant. But that depends on the jury finding that the defendant heard it and understood what it meant. And I would say it to the jury just like that.
I just respectfully.
No, I understand. You've preserved the record very well, and I understand you object to it.
Thank you, sir.
Now, Ms. Megan, do you see some ideological impurity in this approach?
No, Your Honor. I agree that perhaps the safest and best course would be to admit it for both purposes. And if you feel that an instruction is necessary, you could instruct the jury that it's not being offered for the truth of the matter asserted, the matter being the police are here. The government doesn't feel that instruction is necessary because the presence of the police is not a matter in dispute. But you could give that instruction and tell them that it is being admitted not for the truth of the matter asserted, the presence of the police, but for the effect on the state of mind of the listener, with the jury making the determination, as you correctly said, of course, whether he heard it in the first place.
Okay. All right. All right. You see, the reason why this is potentially and I certainly recognize the distinction that is discussed in the cases that you cited. The reason why I think it is potentially confusing in this case is because there's no doubt that the police were there. Now, but it's not necessarily true that the defendant knew the police were there. That is, at least until, your argument would be at least until Brian Seals called out one time.
Yes, Your Honor.
All right. All right. Are the police officers the first witnesses?
Yes, they are.
Okay. All right. Well, I'm going to admit the statement under both theories, and I will give the jury an instruction at the time that the testimony comes in. And if either counsel and then I'll try and remember to ask either counsel if they want to come to sidebar to comment on my instruction. If so, I'll let you do that. But if you don't have to come just to repeat the objection you've already made, but only to clarify. Let me say one more thing about sidebars. I don't like sidebars, and I generally don't have them unless I see some necessity for it. I think we've raised all the legal issues ahead of time. Well, it's 9:15. We still don't have a defendant. You want to make another call, Janice? Thanks.
Your Honor, just a little bit of housekeeping then.
Yes.
We have the exhibits loaded on the computer and they'll come up, but I also have exhibit books. So if I can approach and give one to you and put one up on the witness stand, and I've already provided.
I have one.
Your download.
Thank you.
Your Honor, again, a matter of housekeeping. At the conclusion, when will we have a jury conference?
When the evidence is done before arguments.
Okay.
Okay. Yeah, I don't think you've submitted points for charge. No, I mean, you don't have to. But.
No, I would only request one regarding Reginald Gibson.
Well, he's unavailable.
Right, yeah.
Right, okay.
Yeah.
Okay. And then can you put that on? Because it's long. This way or this way? Okay. Yeah. This is the perils of being short.
Thank you.
Right, exactly. Yeah.
We're going to have to add a charge that Reginald is not available on either side, but the abstained. But I'll go over that action. Let's wait and see. You may have to make some corrections. Okay, we're ready.
Go up. Yeah, you got the key. It'll fit the door.
All right, I give the jury about 7 or 8 minutes of general instructions first,
Okay.
and then but I'm going to let you talk to the client and just tell them what the ruling was.
All right, right. And you'll see, I'm quick.
Take your time.
Yeah. Yeah, that looks better.
We will only even consider 1 through 45. Everything else is just a so you can just check off whichever is the action. Now you have the gun. So what we got here? The gun and what's on here?
All right, Mr. Seals, good morning. We're ready to start the trial. I just want to advise you that while we were waiting for you, I had a brief discussion with counsel on the legal issue that was discussed last Thursday, specifically the admissibility of the testimony of the police officers that they encountered your brother, Brian Seals, who testified at the pretrial hearing, and they heard him yell up the street, one time. After considering the legal issues that were presented by the briefs that were filed last week and some subsequent briefing over the weekend and another case that I located, I've decided that I will allow the police officers to testify concerning testify consistent with what was said at the pretrial hearing. In the first place, there's a credibility dispute between the police officers and your brother, Brian Seals, who denied that he was even present or made any statement. In my view, that does not present a legal issue. That's a fact issue of credibility of the police officers. The legal issue only arises with connection with the content of what the police officers would testify to as to what your brother actually said. And I've determined that that is admissible under Rule of Evidence 803-1 as a present sense impression, or it's admissible not for the truth of the matter asserted, but as a out-of-court statement offered only to show a reaction by someone who heard the statement, and the government argues that you were in hearing distance. Now that, once again, is not a legal issue. That's a question of proof for the government to make and a question of fact for the jury to find under my instructions. So I just wanted to let you know what the ruling was. Mr. Automotive, would you want a few minutes to discuss that with your client?
Just a couple of minutes, Your Honor.
Go ahead.
Okay, so do we have the gun? Do we have the gun, Laura? Do we have the gun, Laura?
No. Okay, are you done?
Yes, sir. Yes,
Okay. All right, bring the jury in, please.
Yes.
Okay.
Whatever you need.
Yeah, let's pass.
Yes.
Oh, a scissor? Yeah, a scissor, don't you?
To look good. Oh, no. No.
Counsel on the scene.
All right.
Okay, everyone, please be seated. Please, good morning, ladies and gentlemen of the jury. I'm sorry we're a few minutes starting late today. It's nobody's fault in particular, just some details and other issues that had come up, but we're now ready to begin. The first item for you is that I'm going to give you what are referred to sometimes as general instructions. These are things that have to do with the conduct of the trial and your duties and obligations as jurors, and they are the same. I give the same instructions in every case, and they're just for your general benefit, and don't have anything to do with the facts of this case. The first thing I want to do is describe to you how a trial proceeds. This little discussion I have will take another 6 or 7 minutes. Then we have opening speeches of counsel. And the prosecutors will go first because they have the burden of proof. And this is an opportunity for them to give you a roadmap or an outline of their case. And they will explain what they intend to prove. One reason we do this is that the counsel in the case can only call one witness at a time. So this gives them a chance to give you sort of the coming attractions or a preview of what their evidence is going to be. So they will outline to you what witnesses they're going to call and what witnesses and what testimony they're going to present in an effort to prove to you that the defendant is guilty beyond a reasonable doubt, which is what their burden is. And I want to emphasize to you that the opening address of either counsel is not evidence. The arguments of counsel are for you to consider, but they're not evidence. Now, when the prosecutor is done, then defense counsel has the option at that time to give an opening address, or he may wait until the government has finished its entire case. And the same rules apply to him. The defense counsel can explain to you what he will attempt to show you to show that there's a reasonable doubt as to why you should not convict the defendant of the crime charge. Then when we're done the opening addresses, which will probably be fairly short, then the government will start presenting its case. And the government presents its case by calling witnesses to the witness stand and introducing exhibits into evidence. All of the witnesses testify under oath, and their credibility is for you. And you're the finders of the facts. So the most important thing for the jury to do is to find the facts. You do that by listening carefully to the testimony of the witnesses and determining their credibility. Credibility is a fancy word for believability. And it means do you find that the witness's testimony is trustworthy so that you're willing to rely on it. And I'll have more to say about this at the end of the case. But just to give you an example that has nothing to do with a criminal case, suppose you had an automobile accident, a right-angle collision, and there was a traffic light there. And there were 3 witnesses on different corners, bystanders. And one of them said that the Buick went through the red light, and the other 2 said that the Ford went through the red light. Okay? So there was a conflict, and there was a trial about this, and they all came into court and testified. Now, none of them are lying. You'll all find that they're trying to tell the truth, but their testimony is different. And you have to decide to whom to give greater weight. That is, who was in a better position to observe? Who's the most reliable? Did one make any contradictory statements? Did one seem inconsistent? Is one more unsure than the other? And things like that. That's what credibility is all about. If you find a witness is lying, well then that's certainly something that you want to take into account in determining credibility. But you may find that witnesses are credible, but some witnesses are more credible than others just because of the nature of their testimony, the value of their recollection, and things of that nature. So when we talk about credibility, we're talking in a broad sense the trustworthiness of the witness. So the government will call its witnesses one by one. And then when the government's done, then the defendant has the opportunity to present testimony if the defendant wants to. But in the criminal case, the defendant doesn't have to present anything because the defendant is presumed innocent. The burden of proof is always on the government. And when all the testimony is done, then the counsel will come back to you and they will present their closing arguments. And at that time, they will sum up the evidence and try to persuade you to cast your verdict in favor of their client.
And then when that's done, then I will give you the charge of court, and I will explain to you the legal principles that must guide your deliberations. Now, during the trial, it's most important that you hear, if for any reason you haven't heard the testimony of a witness, raise your hand, and we'll stop the testimony and take a minute to repeat it or make sure that you've heard all the testimony. Because you're the jurors who are going to decide the case, you have to have heard the testimony. Similarly, if any of you have an emergency, need to go to the bathroom or something like that, raise your hand about that as well. Now, you've been given notebooks, and you're welcome to take notes. Some jurors take a lot of notes, some jurors don't take any notes. It's completely up to you whether you take notes or not. But the notes are for your personal use only. They are not evidence, they're not for trying to persuade other jurors of your point of view. They're to help you recollect evidence. Now, this is not going to be a long case, so if you're welcome to take notes and write down any names or dates or anything else you think is important. But this is not going to be, some cases stretch on for weeks, and therefore notes can be important in helping jurors remember what took place some time ago. You've been given juror badges to wear. It's important that you wear them when you go out into the hallways and use the elevators and the first floor. Because people who work in the courthouse know that if you're on a jury, you should not be approached or spoken to in any way. I doubt anyone would try to speak to you about this case. If that were to be the occasion, you should tell one of the court officers or myself. But you will also find that the lawyers won't say hello or goodbye or anything else to you, and that's because everybody who works here and tries cases here know that verbal and eye communication with jurors is just not a proper part of the etiquette. So don't feel that anybody's being rude to you by not being conversant. It's also very important that you not discuss the case with anyone, including discussing it among yourselves, until all the evidence and the arguments are over and you're deliberating. The reason for that is that